Welcome to Bar 10 Explanations, How to Read a Case. Law school, particularly the first semester, may be one of the most stressful times you've ever experienced. You're exposed to a new way of learning, thinking, and writing. Further, you're learning a new language, legalese. Much of what you read at first may sound foreign to you, so expect to have to read, reread, and reread again. Expect to spend significant time, much more than you think, on reading just one court opinion. You'll have to read cases multiple times to gain a clear understanding of them. This is very true when students are first learning to read cases. In fact, one of the reasons that students have to reread cases is that they often jump headfirst into reading the text of the case with their highlighters in hand. When students look back through the case, they find that most of the case is highlighted. Ultimately, they can't figure out which pertinent concepts were supposed to be extracted from the case. Jumping in and highlighting right away is an inefficient way for novice legal readers to begin reading casebooks. The first step should always be simply read the case. Resist the urge to have a pen, pencil, highlighter, or laptop computer handy. Simply sit and read. Understand what happened to the parties in the case, who did what to who, understand what specific legal issue the court's addressing, understand what the rule of law is that the court's applying and explaining, understand what the court decided. Once the case is read once, you'll have a much better feel for what the information that's important is. Then you can pull out that highlighter. After you've read the case at least once, maybe more than once if the case is particularly complex or lengthy, or if you're just getting started, now you can get out your pens, pencils, and highlighters. You're now in the active reading and note-taking phase of reading a case. Since you're familiar with the case from your first read-through, read the case again and start to highlight and to make notes in the margins for the following information: name and citation of the case, court and date, procedural facts and posture, facts, issues, holdings, reasoning or rationale or rules, judgment or disposition, dicta, and concurring or dissenting opinions. Before these parts of a court opinion are defined, keep in mind that these sections won't always be spelled out for you, and you'll generally have to sift through the entire opinion more than once to be able to find each part. Typically, the first two pieces of information for a case in a casebook are the parties to the lawsuit and the citation. First, for the parties to the case, note the parties' names and also note their titles in the lawsuit. Who's the plaintiff? Who's the defendant? Appellant, appellee. Second, the citation is the address of the case, which is where the case can be found in print or in an electronic source if you're looking for it. The next two pieces of information for a case in a casebook are usually the court and the year. The court simply is the court that decided the case and drafted the opinion that you're actually reading. The year, of course, is the year that it was drafted. The procedural facts or posture is the part of the opinion that tells how the case proceeded through the court system and ended up before the court that drafted the opinion you're reading. Most of the cases you'll read in casebooks are appellate level cases, which means that the case already was decided by a lower court, but at least one of the parties appealed to the next highest court. You would want to know who sued whom, who won at the lower level, who appealed, and what issue or motion is being appealed. You also might take a note about whether the case is a civil or a criminal case. The facts of the case are sometimes called the evidentiary facts. Simply, the facts are the story underlying the legal dispute. Who did what to who? Why are the parties in court? The key with identifying the facts of the case is figuring out which are the legally relevant facts. In other words, some court opinions have numerous paragraphs of facts. You usually don't need to know all of those facts. You just need the ones that are relevant to the legal issue for which you're reading the case. A legally relevant fact is a fact that mattered to the court in reaching its decision. If you change a certain fact and a different outcome might have been reached by the court, then that fact is generally legally relevant. The issue is the legal question that the court decided. This issue may take several forms. The court may be deciding a pure legal issue, which is when the court's deciding what the meaning of the law is. For instance, a court may decide whether a standard of care for tort is negligence, recklessness, or willful and wanton conduct. Courts also decide issues that are specific to the case facts and their application. The holding is the answer to the legal issue. Sometimes the holding will be a simple yes or no answer. In other words, the issue may be the following. In a claim for emotional distress, did the defendant act recklessly when he shouted obscenities at the plaintiff while knowing that the plaintiff suffered from severe depression? The holding could be as simple as yes. The reasoning or rationale part of the opinion is one of the most important parts for class preparation purposes, as well as for your own understanding of the opinion. This is where the court explains why it reached a holding that it did. One of the first things you want to look for are the rules of law that the court's interpreting or applying to the case facts. Look for a statute, a regulation, a common law rule that the court's interpreting or applying to the case facts. The next thing you want to look for is how does the court interpret the rules and apply them to the case facts. The goal here is to mark or highlight all of the relevant rules and the relevant reasoning. The judgment or disposition is the procedural relief awarded by the court. Because casebook opinions typically are appellate level opinions, the judgment often is whether the court reversed or affirmed the lower court's decision. Simply put, if a court approves or ratifies the lower court's holding, then the appellate court affirmed the lower court. If the court revokes or overthrows the lower court's holding, then the appellate court reversed the lower court. If you read that the appellate court remanded the case to the lower court, then the case is sent back to the lower court for further action, such as a rehearing on a litigated issue or even for an entirely new trial. Some opinions contain dicta. Dicta is defined as statements that are made by the court that are actually not required to decide the particular case before it. In other words, dicta is extraneous information that the court added to the opinion. That can be read as fluff, likely in its explanation of the reasoning. Dicta is important because it may help you predict outcomes in other similar situations. When a judge did not agree or entirely agree with the majority of the judges, a judge may file either a concurring or dissenting opinion. Typically, these will be redacted from casebooks if they're not important to the concepts that your professor is teaching. However, if the casebook does include these opinions, then read them carefully. The opinions may help you to understand the majority or the possible flaws in the majority opinion. As you read other cases in the particular section, you should begin to look for connecting points. Many of the cases will show an evolution of an idea of law or carve out exceptions. This is important to notice as this will generally also be a significant portion of in-class discussion and likely be on your tests. Mind map. Usually a mind map to show the connections between cases and within sections of your class is extremely helpful. So, how might you approach a case in a casebook more efficiently? One of the most overlooked and obvious steps you should take is determining where the case fits into the big picture of your class. Be sure to note in which chapter the case falls or in which subsection or subsection the case falls. Note the headings or subheadings throughout the chapters. They're clues about the concept the professor expects students to extract from the assigned case. For instance, using the torts example outline, if a case falls in a chapter about intentional torts under a heading of intent, then you would expect to read that case for the meaning of intent. You wouldn't expect to read that case for a negligence concept. While this may sound obvious, many students overlook these easy clues. Thank you for watching Bar 10 Explanations, How to Read a Case. We hope you found this video helpful as you prepare for law school. And don't forget, as with most legal skills, you'll only get better with practice. Therefore, don't get discouraged if reading and briefing cases seems to be difficult at first. And don't be discouraged if your first case briefs contain too much information or contain information that needs to be revised after class. With practice, you'll improve and you'll get this down to a science. Thank you for joining us on Bar 10 Explanations. Please like, subscribe, and click that notification bell so you can be updated every time we upload new content. We generally upload new content at least every day at 8 a.m. Eastern Standard Time.